We've recently come across certain issues and misunderstandings when it comes to fixed-term lease agreements and when these fixed-term lease agreements actually become month-to-month agreements. The circumstances in our specific matter that we're looking at came about when a fixed-term lease agreement that was approximately 12 months in period came to an end, and the tenants simply packed up and left the premises, leaving the landlord with no tenant because the landlord had simply assumed that unless the tenant informed him that he was vacating, that the lease would continue on a month-to-month basis. If we go to the origins of these types of fixed agreements, if an agreement is for a fixed period of time, so say for example it's from the 1st of January to the 31st of December, the notion that there's any sort of automatic renewal after the 31st of December is not actually intuitive. One should actually assume that the lease agreement will come to an end on the 31st of December unless stated otherwise. So why do we assume that it rolls over into a month-to-month agreement? The reason for this is because our legislation dictates that it does. So if both parties continue to act in accordance with that agreement past the expiration date, it will automatically be based as a month-to-month agreement. Now, this is very, very common when it comes to rental housing. Tenants will remain on the property past the expiration date. The landlords will tacitly accept this and be happy and consent to the tenant remaining on the property, and the lease will simply continue on a month-to-month basis. The problem is that this is a bad assumption for any landlord to make. The reason for this is some lease agreements do state that 30 days prior to the lease expiring, so let's go back to the example of 31st of December. So by 30th of November, if the tenant intends to vacate the premises, he needs to give written notice to the landlord to do so. Now the lease agreement states this, and it also states that if the tenant fails to do this, the lease agreement will continue on a month-to-month basis. The problem is that in law, this is not actually the case. The Consumer Protection Act requires that if there is any automatic renewal, and that is an automatic renewal, because it requires a tenant to be aware of the expiration, and failing any action by the tenant, it will automatically renew on a month-to-month basis. Now, in our legislation, the Consumer Protection Act, it states specifically that if there is any talk of auto-renewal, that the landlord must give the tenant notice of the expiration date and the automatic renewal between 40 to 80 business days prior to the expiration of the lease. Now, you'll notice that the lease agreements also state this in a separate paragraph. And the problem is, although these paragraphs aren't interlinked and don't refer to each other, one cannot happen without the other. And so the automatic renewal for failure of the tenant to send that 30 days notice prior to expiration will only apply if the landlord took the necessary steps to give the tenant notice of the expiration and notice that he is required to let the landlord know 30 days prior that he is moving out. If the landlord did not do this, the tenant is entitled to pack up and leave because the lease has come to an end and there is no automatic renewal. So this month-to-month lease agreement is great in practice because many tenants stay on the property past expiration. Unfortunately, it does take certain steps on the landlord's part in order to ascertain whether it is going to apply, whether the landlord will continue having a tenant after expiration, and allow the landlord time to possibly find a new tenant or renegotiate the terms of this lease agreement. It's also very important for the landlord to do this because if the landlord has any intention of increasing the rent, it must do so in this notice required in terms of the CPA. and cannot simply, on the last day, advise the tenant that if he continues to stay on a month-to-month basis, that the rent will simply increase, because in those circumstances, again, it's a month-to-month lease agreement. And if the tenant chooses to do so, he or she will simply give 1 month notice and vacate the premises. And the landlord will not be entitled to charge the escalation on the first month until he's given the opportunity to the tenant to renegotiate those terms, failing which the landlord will give notice. So it is very, very, very important to be aware that these two clauses must coincide with each other, must act collectively, and that a landlord needs to be aware of the time periods when it comes to automatic renewals.